Hello, this is Wayland Chow. This is Contract Terms, Part B, which focuses on standard form agreements and exclusion clauses. Let's now look at standard form agreements. They are preset contracts that are set up in advance by businesses to do repetitive transactions with customers. There are huge advantages with using standard form agreements. They facilitate the efficient execution of business transactions, but there are also some concerns regarding the potential abuse of consumers. In facilitating business transactions, standard form agreements reduce transaction costs. There's no need to negotiate a new contract every single time a business does a transaction that it may typically do over and over again. And by having a standard contract that is set up in advance, usually by the business's lawyers, the contract hopefully is properly drafted in a way that will reduce the legal risks of the business, especially by including exclusion clauses. There are potential abuse concerns of consumers through the use of standard form agreements. These agreements are usually provided to consumers as a take it or leave it proposition, where consumers have little or no bargaining power or ability to ask for any change in the terms of the agreement. There's no room for negotiation. Another concern is that very few consumers read or understand what they are agreeing to. And as well, since the agreements are drafted by the business for the business, the terms of these contracts tend to be one-sided in favor of the business. The validity of standard form agreements have been challenged by consumers. In the case of these challenges, the legal issue that the court usually looks at is, did a customer accept the terms of the standard form agreement? Or in other words, are the terms of the agreement binding on the customer? In addressing this legal issue, courts have to balance two competing policy considerations. On the one hand, it wants to facilitate the efficient execution of business transactions with minimal legal risk for businesses. On the other hand, courts also want to protect consumers from the abuses of standard form agreements, especially where the terms are very one-sided in favor of the business. The general rule that courts apply is that if a customer signs a contract or clicks I agree online for an online transaction, the customer is bound by the terms of the contract, even if the customer did not read or understand the terms of the contract. So that is the general rule. Now, the courts, in considering the need to protect consumers, have carved out a couple of exceptions. The first exception is where the contractual term is considered to be onerous or unusual. In that case, the customer must be given reasonable notice of that term and also reasonable opportunity to understand what they were signing. This comes from the case Tilden and Clendenning, which we'll look at in more detail in a moment. The second exception is where the term is a limitation or exclusion clause. To be a valid clause, the term must meet a number of requirements. A, it has to be clear and unambiguous. B, there must be reasonable notice to the affected party. C, the affected party has provided their acceptance of the term. D, the term is not unconscionable or unfair. And E, it is not against public policy. An important case regarding the validity of standard form contracts is the Ontario Court of Appeal decision in Tilden Rent-A-Car and Clendenning. In that case, we have a Mr. John Clendenning. He rented a car from Tilden Rent-A-Car. So that involved a standard form car rental contract. So at the time of rental, Mr. Clendenning had decided to purchase at extra cost in collision insurance coverage that would cover the value of the car in case he got into an accident. So he got the car from Tilden, drove it away, and during the time of his rental, one evening he went out for some drinks, and unfortunately he drove the rental car, after having consumed the alcohol, and got into an accident. When Mr. Clendenning tried to claim for the value of that damage to the car, with the insurance that he bought under the car rental agreement, Tilden Rent-A-Car refused to cover the value of the damage to the car. They pointed out to Mr. Clendenning a clause in the contract which says that the insurance coverage will not apply if the customer had consumed any quantity of alcohol. So that clause was, in the terms of the contract. It was, part of, I guess, what you could call the fine print. It was buried deep in the contract. It was actually on the flip side of the contract. So Mr. Clendenning, challenged Tilden in court regarding the validity of that clause. So the Ontario Court of Appeal, in that decision, said that the signature of Mr. Clendenning on that standard form contract was not a true acceptance of the contract. And the basis of that conclusion was that this clause regarding excluding the insurance coverage when any quantity of alcohol had been consumed, the court regarded that clause as being onerous and unusual. I think they saw it as too extreme in terms of consuming any quantity of alcohol disqualifying the coverage, as opposed to some other level of alcohol consumption, such as the legal minimum in terms of impaired driving. So that clause was onerous and unusual, and the court said, if you're going to have an onerous and unusual clause in a standard form contract for consumers, there has to be two things. There has to be reasonable notice given to the customer of that onerous and unusual clause, and also the customer needs to be given reasonable opportunity to understand and appreciate what he was signing. And in this case, Mr. Clendenning was neither given reasonable notice nor reasonable opportunity, and therefore that clause was invalid, and Tilden should cover the cost of the damage to the car.
The clause that we looked at in Tilden and Clendenning could be called an exclusion clause, because it does limit the liability of the business in a certain circumstance. So in that circumstance was where the customer had consumed any alcohol, then that would cause Tilden, the business, to not be liable based on the wording of the contract, at least. So exclusion clauses are also commonly called limitation clauses or waivers. So they are used to eliminate or reduce the potential liability of the business. So they may exempt the party entirely, for example, that they're not liable for any loss, or they may exclude certain liability, example, not liable for carelessly caused damage, or they may cap the amount or limit the amount of damage, for example, limiting liability to a certain amount, let's say $500. They do serve a valuable, practical economic purpose, because they do facilitate transactions by reducing a business's legal liability risks. If not for exclusion clauses, businesses could face fairly large liabilities for transactions that are proportionately very small compared to those liabilities. And therefore, many businesses would avoid doing a lot of those transactions altogether. But being able to use exclusion clauses to reduce that liability exposure, that does encourage businesses to enter into more economic transactions. So we will look at, for our examples, for many of our examples, to the Rogers Communications Terms of Service. So this is a contract that some of you may have entered into if you are a Rogers subscriber for your cell phone. The exclusion clause for Rogers is found in Section 29 of that agreement.
Here is Rogers' terms of service. So this is the standard form agreement that Rogers used to use. It's actually not the most current one, but this is useful for us in terms of illustrating, how exclusion clauses are used in standard form agreements. So this is the Rogers terms of service that they used as the contract between Rogers and its customers. So the exclusion clause is found in Section 29. So what I'm showing you here is really just the first part of Section 29. Section 29, the exclusion clause, goes on for much, much, much longer. But let's have a look at this first part. I think it gives us a flavor of how this exclusion clause is set up and what it's meant to accomplish, especially in limiting Rogers' potential liability. So let's just very quickly read this. So Section 29. It says, and I'll skip various wordings, so I'm not going to read everything verbatim. It says, to the maximum extent permitted by applicable law, the Rogers parties, so they're referring to the various Rogers companies, the Rogers parties will not be liable to you, which is the customer, or to any third party for any direct, indirect, special, consequential, incidental, economic, or punitive damages, including loss of profit or revenue, financial loss, loss of business opportunities, loss, destruction, or alteration of data, files or software, breach of privacy or security, property damage, personal injury, death, or any other foreseeable or unforeseeable loss, however caused, resulting or relating directly or indirectly from or relating to the offering or any advertisements, promotions, or statements relating to any of the foregoing, even if we were negligent or were advised of the possibility of such damages. And then it also says the performance, availability, reliability, timeliness, quality, coverage, uninterrupted use, security, pricing, or operation of the offering. The offering is basically encompasses all of the various services that they sell to customers. Now let me catch my breath a bit after reading all that. As I said, that's only the beginning of it. So what they're clearly trying to do is they're trying to think of everything, every possible loss or damage or injury that a customer or any other third party may suffer in relation to the services that Rogers provided, and saying, we're not liable for any of that. The importance of that exclusion clause in the Rogers contract became very relevant in the aftermath of the major network outage that Rogers suffered in July of 2022. In that major outage, more than 12 million users of Rogers' cable, internet, and cellular networks were affected. And the total economic toll to the Canadian economy for that outage was estimated to be at about $142 million. So many people wondered, could Rogers be held legally liable for all of the losses that people suffered because of that network outage? The courts in case law have developed some specific requirements to determine the validity of exclusion clauses. The first requirement is that an exclusion clause must be clear and unambiguous. The language needs to show that it clearly applies, the clause clearly applies to a particular situation at hand. And if there are any ambiguities, the clause will be interpreted in a way that goes against the drafter, meaning against the business and in favor of the consumer. The second requirement is that the consumer, the affected party, has to be given reasonable notice of the exclusion clause. The third requirement is that the consumer has to provide acceptance of the exclusion clause or of the whole contract. So that can be in the form of a written signature at the bottom of a contract. It can be a verbal statement. It can be clicking I agree for an internet contract, or even better, having the consumer initial or click their agreement with respect to a specific exclusion clause. So initially right beside it, or clicking something that specifically acknowledges that exclusion clause. The fourth requirement is that the exclusion clause is not unconscionable. Later in this module, we will look at the specific requirements for the doctrine of unconscionability. But the two general requirements for unconscionability is a substantial inequality of bargaining power and substantial unfairness of the terms, or with respect to exclusion clauses, substantial unfairness of the exclusion clause itself. The fifth and last requirement is that the exclusion clause is not against public policy. There we are looking at a broader issue. Does that exclusion clause go against the general interests of society? So based on these 5 requirements, does the Rogers exclusion clause meet these requirements? Let's now go back and have a closer look at that Rogers exclusion clause from the Rogers Terms of Service. And I just wanted to note that this exclusion clause comes from the Terms of Service agreement that was in effect from a few years ago. There is a more current Terms of Service agreement, but the exclusion clause is very similar to the one that we are looking at. So let's apply those requirements for the validity of an exclusion clause. So was the exclusion clause clear and unambiguous? So we've already gone through a lot of the specific language in this exclusion clause. It is very long, it's very detailed, and it goes on and on and on. There are many legal terms in it, which I think the average person probably would not understand. So I'm not entirely convinced that it is clear. Is it unambiguous? I think there's enough there, especially if you look at the portion that's reproduced on the screen there. I think there's enough there to say that whatever economic loss that someone may have suffered because of the major network outage, that this clause would cover it, would apply to it, to say that Rogers is not liable for that loss. But is it as a whole clear and unambiguous? I'm not entirely convinced, but I think probably on balance, I think Rogers would be able to make a very good argument that it is clear and unambiguous in terms of how it applies to that specific situation of the consequences flowing from the major network outage. The second requirement is reasonable notice. So were consumers given reasonable notice of this exclusion clause? So this exclusion clause is written in bold to give it more emphasis and to draw people's attention to it in the Terms of Service agreement. However, it is buried within the contract. It is clause number 29 on page 4 of a 9-page contract. What I wonder about is with regard to the procedure that consumers enter into or are subjected to when they enter into contract. If it's with a sales rep, does the sales rep point out this exclusion clause to them? Do they get the consumers to initial the exclusion clause? If the contract is done online, is there some part of the online process that points out this exclusion clause to consumers, and are consumers asked to acknowledge and agree to this specific exclusion clause? All of that would be relevant in determining whether or not there was reasonable notice. Acceptance. I think, yeah, there's clearly in 99.9% of situations that customers have accepted this exclusion clause when they either sign on the whole agreement, sign off on the whole agreement, or click I agree on the whole agreement. I think that would be considered sufficient acceptance. The fourth requirement is unconscionability. So we specifically ask a couple of things here. Was there a substantial inequality of bargaining power between Rogers and consumers, its customers? Um, the inequality of bargaining power here, I think, can be described as being, Rogers is this big company. When you want to get service from Rogers, they provide you with a standard form agreement. The terms of that agreement are not negotiable. It's a take it or leave it kind of proposition. Individual customers don't have the ability, don't have the bargaining power to negotiate the terms of that agreement. On that basis, I think an argument could be made that there was a substantial inequality of bargaining power, especially in light of the Supreme Court decision in Uber Technologies and Heller, which we will talk about later in this module. And that case also involved unconscionability with regard to a standard form agreement. The second question we need to consider with regard to unconscionability is, was the exclusion clause substantially unfair? Or another way of looking at that or saying that is, was the exclusion clause one-sided in favor of Rogers? And I think a good argument could be made here as well, that there was substantial unfairness. When you read through this huge, long exclusion clause, you realize, this is pretty one-sided. It's basically saying that, Rogers can't be held liable for almost anything, because they just go on and on with all these different things that they cannot be held liable for. So it certainly comes across as being very one-sided in favor of Rogers. The last requirement or consideration is this exclusion clause against public policies? Public policy is a difficult thing to understand. What we're looking at here is, beyond this particular contract, beyond this particular case, is it good for society as a whole to protect companies like Rogers from liability for these major events like that network outage from July of 2022? So there could be arguments in favor and against. You could say that it is good for society to protect companies like Rogers or Bell from liability here, because if they were subject to full liability, it could drive them out of business, or at the very least, it could cause them to raise rates in order to cover the potential liabilities that they would incur from operating their business. A counter argument to that is that by making companies like Rogers not liable at all, it does not give them an economic incentive to provide better service, to make sure that their networks won't go down again, and to design their networks with redundancy so that if one network goes down, there is another network to back it up. So I think there are good arguments for and against public policy. And as a whole, I don't think it's entirely 100% clear, based on these 5 requirements, that the exclusion clause is valid. I think there are some good arguments to say that, based on some of these requirements, that the exclusion clause may be invalid.
Let's now have a look at this quick quiz question. Please take a moment by pausing this video and reading through this question and considering your answer. I won't take the time to read through this whole question. You've read through it yourself, I hope. but let's go through the different choices. But before we do that, I'll tell you the answer is E. But let's start with A. By by actually reading the exclusion clause, so that's not the answer, because requiring that someone read it is not the only way to bind them to an exclusion clause. If everyone had to actually read a contract to be bound by it, most of our contracts that we enter into would be invalid. So that definitely is not the right answer. B, it was written in a font that was larger than the font that otherwise appeared on the ticket. So that is one way of ensuring there is reasonable notice. But the way the question is worded is, if you look at the last sentence before the choices, assuming these are the only exclusions, pre-PAL can be bound by the exclusion only if. So having it written in a font is one way of providing reasonable notice, but it's not the only way of providing reasonable notice. And similarly with C, the clause was written in a language that she can read. So having it written in plain English is one way of ensuring the exclusion clause is valid, but it's not the only thing that we look at to ensure that the clause is valid. D, it was explained to her when she first bought her train ticket. So having the exclusion clause explained to pre-PAL is another aspect of achieving reasonable notice, but it's not the only way of achieving reasonable notice. So E is the only statement that is really correct. She was given reasonable notice of the terms on the back of the ticket before or at the time that she received the ticket.